May it please your sir.
Yes,
My lord, I may be allowed to move unlisted motion. My lord, this is
unlisted motion.
yes, ma'am. This is just to issue notice only.
Before one.
Hold on.
Lordship, here also, Lordship.
Before one.
Before one, Lordship, we'll try.
Say, my lord, yesterday's matter, my lord, there is a technical issue. Some mention needs to be made before your lordship for listing event before the law court number 2. The RNC was not listed. Last order passed by your lordship, but before appropriation. Now, today also, my lord, so I am praying for the my lord, the listing of the matter, which is already pending. For issuance of notice on the court number 2.
Court number 2.
Yes, sir.
No, if it is listed before the court number, it is court number 2.
But what I am praying for is for the listing of the matter at court number 2. There is a procedure, matter as per the procedure, matter the mention should be made before your lordship, or even for the listing of the matter before court number 2. Just only for the issuance of notice.
Should be listed before whom?
Court number 2, man.
How can I allow that? How can I allow that?
Procedure as per the procedure, the mention is to be made before your lordship, or even for the listing before the court number 2.
Is it so?
Yes. Senior judge, mention is to be made before the senior judge.
She will have difficulty today. List here. She has some difficulty. She is leaving early.
But only for the issuance of notice.
Then
Because of the technical problem, matter was not notice was not issued even.
okay. Hello. You go there and convince her.
May it please your lordship. Lordship, when in connection with item number 10 was filed today morning, it may be called for
What's there? Item number 10.
election petition, lordship.
Okay. Hi. Hold it.
Hi, lordship.
Lordship, Lordship, unlisted motion for this.
Can't help it. Yes, any instruction?
My lord, as per instruction, my lord, earlier entire pension document was earlier submitted to Director Audit and Pension, for process, my lord. However, same was returned back as MSCP, my lord, in respect of the demise her husband, my lord, was not finalized by the government. It was not approved. So that's why it was returned back. So again, on receipt of the file again from the Director Audit and Pension, my lord, we have put up the matter to the government for since before the MSP is clear, approved, the incumbent expired. That's why for that, my lord, as soon as that MSCP part is clear, because unless MSP is clear, is not clear, it's not approved, the Audit and Pension, they have a problem, my lord. That's why we have put up for the government for approval, and as soon as it is clear, my lord, we'll again return back to the Audit and Pension for clearance all. And as of today, my lord, the all retirement, gratuitous leave, encashment, all what is entitled has been released by the department. Only pension part is required, my lord, for clearance by MSP. That part.
Will allow you withdraw it? Will allow to come back if it is not done?
Yes.
Because we just cannot make it a kind of a scarecrow that you must do it, you cannot. There's a process.
Bona
It takes
fide,
time.
the government is doing, my lord. We are speeding up.
We'll say that we'll record his submission. It's under active consideration. It has been already processed. It's under active consideration in view of the withdraw the writ petition. We will give you a liberty. Okay, because it takes time. No, it's not. I mean, it's a government. I mean, departmental functions are there from table to table, authority to authority. It takes time. Wait for some time. Have some patience.
Yeah, that is there, Lord, but it's been more than 1 year and 6 months.
It's okay. They are saying we'll record his submission. We'll close it, huh?
Yeah.
will give you a liberty. Liberty is also not necessary. You will
Always there.
again come back. You can come back always. Heard Mr. Ibam, learned counsel for the petitioner. A grievance of the petitioner is to the effect that the responding authorities have failed to process the pension papers in respect of her late husband, who was working as vice president in the education department and had unfortunately died on 29/10/2023. Considering the nature of the grievance, this court on 02/07/2025 directed the learned standing counsel, Mr. T. Thagum, to obtain instruction. Next, today, Mr. T. Thagum submits that. On instruction, submits that. The process of pension papers is under active consideration, as in when the papers, as in when the same is clear, it would be sent to the audit and pension
Yes.
department. Having considered, in view of the above, Mr. Ibam, learned counsel for the petitioner, submits that the writ petition may be closed. What do you say?
This week. Can we close it? It will be done, madam. I talked personally to the authority, the bona fide letter.
If my brother is submitting that, then I will be like to withdraw my matter.
In view of the above instruction from Mr. Ibam, learned counsel for the petitioner, fairly submits that if the matter is under active consideration and it would be done, if it is done within a reasonable time,
Yes.
he would not like to pursue the writ petition at this stage. Mr. Next, consider the above. A writ petition stands closed with a liberty to approach this court again. If approach this again, liberty to approach this court again. Mr. It is expected that the responding authorities shall do the no, they shall complete the process as expeditiously as possible. Mr.
Deeply obliged.
Writ petition stands closed.
May I please, Lordship?
How many days?
Lordship.
How many days
one
to
month,
vacate?
1 month, Lordship, on health ground. 1 month, on health ground,
1 month.
please.
You will direct you to approach the deputy commissioner or the state officer.
State officer, he is the competent authority. We have prepared appeal also, and appeal has been also disposed of and uphold the decision of the order of the ADC. So
Okay.
we may be allowed to approach the ADC. Don't worry.
Heard Mr. Will dispose of the matter.
Yes.
To vacate, will grant you 1 month time to vacate.
To approach with the appropriate application.
Hmm?
To approach.
No, this is no question of, what I'm saying is you vacate it
As per
within how many days
1 month,
to vacate?
1 month.
To vacate?
To arrange.
No, to vacate the land.
Lordship,
Vacate means within 1 month you arrange and vacate up
yeah.
within 1 month.
For that purpose, I will approach the ADC. ADC will take that decision, Lordship. 1 month, I may be given to approach
But
the
we're not
ADC.
passing any interim.
Lordship.
Admitted it's a government land. Just
Lordship,
because you have illegally constructed, you just cannot be removed within a, short period, you need to,
because since
find out the
10 years,
alternative location,
Lordship.
I mean, the accommodation.
Since last 10 years, the authority has never issued a
Doesn't make a
notice, and
difference.
therefore, I also.
It doesn't give you a license, sir.
At 1 month, Lordship, and then I will approach the ADC, and ADC will take appropriate action.
No, we'll grant you 1 month time
Yes.
to vacate. Till such time, it shouldn't be given effect. That's
Okay,
all.
Lordship. Okay,
All right.
okay.
Yes,
It's reasonable.
for vacation.
Let them have that. I heard Mr. X. Javier, learned counsel, no, ex Getty, learned counsel for the petitioner. And also had MS Arbasar, learned counsel, state counsel for the learned state counsel for respondents. Essentially, the petitioner is aggrieved by the what is the
Page 11,
eviction notice?
page 11.
Yes, it should dated 16/05/2025, passed by the ADC cum state officer Dumpurija, Upper Subansiri district. And the whereby the petitioner has been directed to vacate to dismantle, to remove oblique dismantle the illegal structure constructed by the petitioner and to vacate the place within 20 days. Please stop. The petitioner is also and also the order dated 27/06/2025, passed by Deputy Commissioner Upper Subansiri Dapurija, whereby the appeal against the eviction notice passed by the ADC cum state officer Dapurija has been dismissed. Mr. Petitioner, next para, claims to be in occupation of the land and had constructed temporary house since 10 years back, with an impression that the plot which he has occupied is outside the government notified land. Mr. He claims that he's staying with staying with his family over the plot of land more than 10 years and paying all the charges of government amenities, which would indicate that the government has allowed him to stay on the land. Mr. Mr. Nixpera, ex-Kiati, learned counsel for the petition, fairly submits that in the given facts and circumstances, the petitioner would not have any right over the plot of land, as it has come to the notice that come to the knowledge that the land on which the petitioner is staying is within the government notified area. Mr. However, he submits that in view of the permanent settlement over the plot of land with his family, and having been, the petitioner having been under medical treatment, which is yet to be, which he is yet to be recovered from his illness, a reasonable time to vacate the land may be considered and allowed. List of MS Arbasa Learned Council. LL State Council submits that admittedly the petitioner is an illegal occupant, illegal and unauthorized occupant of the plot of land, of the government land. Therefore, he would not have any right to claim over the land. Next paragraph. Having considered the submissions of learned counsel for the parties and also perusal of the perusal of the materials placed before this court, comma, it is noticed that the respondent authorities has followed the due process of law while issuing the notice and while issuing the notice for eviction and thereafter fair and followed by the state officer as well as the appellate authority under the provisions of as per the provisions of law. List. It is admitted position that the petitioner has constructed a structure near the allotted government quarter of, or near the government quarter at Dimpu region, which is undisputedly within the government notified area. Mr. Next paragraph. In view of the fair submissions and considering the limited prayer made by the learned counsel for the petition, this petition is disposed of with a direction to the respondent authorities, particularly state officer, ADC come state officer to grant a month's time to vacate the land, considering the considering that the petitioner is staying with his family and is undergoing medical treatment. The petitioner shall approach the additional deputy commissioner state of state officer Dimpu region, seeking for 1 month time to vacate the land, on which the ADC come the state officer shall consider and allowed shall consider and allow the same. Mr. But till for a month, and list of accordingly for a month the orders passed by so and so ADC come state officer shall not be given effect to.
Okay, all right.
It presents then disposal.
Your Lordship, the petitioners in this case, they have a plot of land measuring 324 and 250 square meters each.
Heard Mr. K. as a learned counsel for the petitioner. Challenge made in this petition is to the allotment order dated 26/05/2011. Where's the allotment order?
That is in page number
18.
18, Your Lordship.
18.
Yes. That copy is in
Issued
page.
passed by the issued by the land revenue, no, deputy commissioner East Siang district in favor of the education department.
Yes, my lord.
For a plot of land measuring 2,849.
My
square
lord,
meters.
22,849.
Okay, 22,849 square meters at Sector B, Pasigat for school complex of Government Middle School, Paglek. Please stop. No, comma. On the, no, continue. On the ground that the petitioners are residing over the plot of, over the part of the plot of land allotted to the education department. Next para. The petitioner claims that they have constructed a dwelling house over the plot of land and are staying. And the petition and the respondent authorities, without issuing a notice, are constructing a boundary for the school, which will
Which will encompass my land.
which will, huh?
The boundary wall will encompass my land also. My land will come under the boundary wall if constructed.
Encompassing their land. Issue notice, returnable by 4 weeks.
Lordship, I may be protected till then.
Huh?
At least the boundary wall may not be constructed.
And the boundary, public
Very
interest.
difficult. As Mr. Which one?
1, 2, and 3.
As in MS T. Wangmo and T. Tagum, London State Council and T. Tagum, London State Government Education Department.
Lordship, if you look-
Enters appearance and accepts notice on behalf of
Respondent.
all the respondents, no formal
For-
notice we need this up. How extra codes furnished to that. There are the
Private
respondent.
respondent also, my lord.
Yes.
The London Council to the state petition to take steps for service of notice upon respondent number
1 and
7, my lord.
7.
7.
Only 7.
Yes, the private respondent. Lordship, if you look at page 23,
It is provided that the deputy commissioner or the state officer may grant some time to the petitioner to vacate the land,
no, Lordship, to
vacate the land if in the event the petitioner approaches them. That's
Lordship,
all.
if you look at page 23, Your Lordship, kindly. Page 23, Your Lordship.
What is there?
It clearly says that their allotment doesn't have map, the page 23.
Why not?
So it shows that even
Sir,
their,
it's a writ court.
then Your
You
Lordship,
approach the deputy commissioner and state officer or the state officer
yes,
and six.
therefore, Your Lordship, I'm saying that I may be given time to approach the deputy commissioner to settle the issue with them.
Huh?
I may be given time to approach the concerned authority.
To vacate
No, to settle
it's
it.
school land.
That is the condition, Your Lordship. It is not school
Sir,
land.
can help it. Sorry,
But at least, Your Lordship, the word vacate may be removed from
it's
the.
clearly allotted. If there is a dispute, if the allotment doesn't fall, you may
Your Lordship,
take,
their allotment is of
appropriate
2011 only, Your Lordship.
Huh?
The allotment is of year 2011.
That's what I'm saying.
And I have been deciding prior to 2011. If we look at the electricity bills, that's
Not that it makes a difference.
District administration will clarify that the land department will make a
You
detailed.
seek time for vacation.
no, Your Lordship, to settle the issue, Your Lordship. Not to vacate, to settle
Huh?
the issue. To settle the issue, Your Lordship. To approach and settle the issue. Because, Your Lordship, if the word vacate is,
How you will settle? It's clearly allotted. If it is not, if your land doesn't fall within the allotted area, nothing, no,
Because
you
you're-
will not be disturbed.
if they take proper survey, it will be seen that my land doesn't come under their land. If they take
You
proper
approach the
survey.
jurisdictional civil court.
Therefore, Your Lordship, I'm seeking time to settle the issue, not to vacate, Your Lordship. Because,
They are not evicting you.
yes, Your Lordship. But Your Lordship, in today's order, if the word vacate is
They
mentioned,
may construct the boundary, I mean, besides your land.
yes, Your Lordship. Therefore, Your
So
Lordship,
you'll be protected.
the word vacate may not be added in today's order. Your Lordship.
Okay, thank you. Sir, what can do now? Only notice. Because it's already been in other, you,
Pending.
whether you have the
Yes.
knowledge or not?
Yes, yes. If I have annexed the document also.
We have provided to, I mean, indirectly, we have not stated the thing also. Allotment. What do you call?
Vested order.
Vesting
Vesting
order,
order.
yes.
Vesting order.
We have allowed it also. So we'll just issue notice.
Yes, yes. Otherwise, I was offering more,
Hmm.
10% more. It is in their interest.
We'll see. Problem is, you could have come before that.
That
notice
is,
passed.
yeah, that is.
Anyway, heard Mr. Deepangan counsel for the petitioner. By filing this writ petition, the petitioner has put to challenge the what do you want? You
The declaration of the respondent number 3 as the subject.
challenge the declaration of the respondent number 3 as successful bidder as the petitioner could not upload the price bid
Right.
due to technical glitches
Glitch.
in the portal of the respondent on the relevant on the day when the price bid was supposed to be uploaded. Listed. The petitioner also offered what do we call better bid or what?
Yes, 10% higher price
Also,
than the respondent
offered
number 3.
10% price higher than the
Respondent number 3.
respondent number 3 list of. Just issue notice,
Madam.
returnable by 4
And
weeks.
for the respondent number 1 and 2. Madam.
Since next period, Mr. M. Learned DAJ enters appearance and accept notice on behalf of respondent number 1 and 2. No formal notice being will be served to the respondent number 1 and 2. However, extra copies be furnished, so and so, huh? Then council petition taking steps for service of notice after respondent number 3 and 4. By registered post so and so, huh? That's all. This respondent number 4 is the one who has filed the writ
Right,
petition.
right.
And the successful bidder is
Respondent number 3.
number 3. Okay. You just name the respondent number 3, namely, huh? In the thing.
Okay.
Develop.
List of the 4. Returnable by 4 week, list of the 4. Yes.
My lord, the petitioner is aggrieved by the action of the respondent authorities in not conducting the interview viva voce for the post of.
Well, issue notice.
Yes, your lord.
What happened?
Lordship,
What happened?
Lordship, we need to seek instructions.
Yes, I think had we had some 1 week time, we could have only asked for it or instruction.
Lordship,
We'll seek instruction. Let us see first without issuing notice. Or should we issue notice?
My lord, can issue notice and the matter may be listed after within a week when the court reopens, your lord.
No, in that case, if you just issue, they may take their own time. Firstly, we would like to know what's the thing. We'll issue notice,
Lordship,
then also instruction.
as well as instruction, your Lordship. Notice can be issued.
We'll issue notice and we'll direct you to obtain
Yes, Your
instruction. And MS Dita learn counsel for the petitioners. Next one. By filing the writ petition, the petitioners who claims to have cleared the written examination for the post of what?
Sub-inspector.
Sub-inspector,
Telecommunication.
telecommunication and radio technician pursuant to the advertisement dated 22/09/2020.
Advertisement date is, your lordship, 8/2/2021.
What?
8/2/2021, advertisement date.
Okay,
Advertisement date is 8/2/2021.
pursuant to the advertisement dated 8/2/2021.
One or 21, sir, Your Lordship.
'21. Six, had prayed for conduct of interview public Bible Bosi. As the interview in Bible Bosi has been postponed due to administrative reasons by an order date, by notification dated 22/09/2022. Mr. Next para. It is submitted by MS the Land Council for the Land Council for the petitioner that the postponement of the interview public Bible Bosi was due to administrative reasons, and there is no other reasons. The selection process has not been cancelled as on today.
No.
Mr. Therefore, not conducting the interview or public Bible voice for a long period without there being any urgent reason, is not sustainable. In a sense, the respondents may be directed to conduct the Bible voice interview or Bible voice for the post of sub-inspector of the telecommunication and radio technician. Issue notice returnable by 3 weeks. We'll say 2 weeks.
Lordship.
2 weeks. MS. All of them. Both of you are.
I'm three, Your Lordship.
Three, you are one.
1 and 3.
1, 2, 3. 3 respondents.
3 respondents.
Since MS P. Pang, London State Council, and MS Anju, London State for APPSC, enters appearance and accept notice, and we have only respond, no formal notice, so and so, so, huh? Next para, considering the issue involved in district police and common MS and London Council for the London Council, London State Council to obtain instruction placed before this court on the next day. 2 weeks, huh?
Lordship.
2 weeks.
Extra copies, Your Lordship.
However, extra copy same, huh?
Obliged.
My lord,
Yes.
this case, my lord, this technical education in India, my lord, this is governed, regulated, and monitored by the All India Technical Education Council, my lord. And by virtue of Act 1987, my lord.
You want that it should be recognized and it should not be.
But it should not be recognized, my lord.
Who are
Because,
you?
my lord, we are the regular, my lord, the serving JE who had acquired the education qualification through a regular course of the education, my lord.
Before
As
regular.
Yes, ma'am. We are the regular, my lord. We had acquired the education through regular mode, my lord.
Then
Now, this department, my lord,
if it is a case recognized,
my lord. Now, my lord, that is why, my lord, yes,
what is your problem?
but the problem, I'll just clarify, my lord. I know that, my lord, this is their language they've used in such a way, my lord. Rather, there's hidden, my lord, the policy, my lord. That's why, my lord. My lord, this
Hidden policy.
all the years, my lord, hidden
If
policy
it
in the
is
sense, my
hidden
lord.
policy, how to interfere?
My lord, I'll show it.
It has to be visible.
Yes, it is visible, my lord.
If it is invisible, we cannot
is-
do anything.
It is expressed in such a way, it make a
Henceforth.
big way. Henceforth, yes, henceforth, word henceforth, my lord. I'll come.
It doesn't, I mean, it
My
may
lord,
be-
That is why, my lord, I'll
Likewise-
just show. Also, my lord, they're accepting this particularly the Department of PHE, my lord.
What is
Public
that?
health-
What is that order?
My lord, I'll just show, my lord, how they are
What is
accepting
this
the,
order? I understand.
my lord, they're accepting. I'll-
Admittedly, adjourned today, after 2009 to
10,
2010.
yes, my lord.
It will not be
Yes, they're not.
recognized.
Now, despite
But then you are agreed by the office.
order dated
what it is?
6 May 2049, henceforth, my lord.
Huh.
Word henceforth, my lord, this word henceforth is substantiated, they will recognize from date of issuance of
Is
this.
there any instances?
Yes, yes, my lord.
In
I'll
view
come.
of this, this has been.
Yes, 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 my lord. They've been
Recognized.
accepting, my lord.
Hmm.
My lord, to see, gradation list, my lord, I'll show the gradation list, they're accepting the diploma or education qualification acquired through distance education. I'll just show one instance, my lord. There are so many, my lord. The gradation list at page 21, my lord. I'll just show, my lord. Page 21, my lord. And so many there, but relevant para page 22, my lord. Example, my lord, also serial number 45, my lord. One so and so, my lord.
Coincidentally, this is also a.
Yes, yes, my lord, see, my
So
lord.
I'll not take it up.
No, my lord, that is not, but so many cases there, but just example, this first case, I'll just take
Why
up,
you
my
have
lord.
not given other example?
My lord, it's so there, my lord,
Some
I'll just,
other person.
because this has been,
Why you have selected this ete?
my lord, there's a reason, my lord, because
There is a reason.
yes, there is reason, man. I'll show how it is reason. Man, that is to show that this diploma through distance education, man. Now, despite holding diploma through distance education, man, promotion, the recent promotion order page 48, my lord, see.
48.
Page 48, my lord. Why this is relevant, my lord? Page 48, my lord. But serial number 6, my lord. He has been promoted to the assistant engineer, although he acquired the diploma through distance education, my lord, which is contravention to the policy adopted by the All India Council, my lord, technical education, my lord. It is against this, my lord. That is why, my
Where's the earlier notification?
the
Office memorandum?
office memorandum is page 43, my lord. No, it's not office memorandum, my lord. It's public notice
Public
given
notice.
by All India Council of Technical Education.
Mhm.
But it has
All
been
the existing student. This is of which year?
this is of the bottom, I will see at 13 March 2010, my lord. This public notice was notified, my lord.
The qualification acquired by the engineer through the senior made are recognized for the proper process.
Second para, my lord, it has been made, my lord.
It has been the policy of not to recognize the quality of which
And my lord, similar instances, my lord, even the Honorable Apex Court, my lord, repeatedly, my lord, held that this distance education cannot be accepted, my lord. And the entire regulation of technical education should be absolutely left to the All India Council of Technical Education, my lord. Recently, in Odisha Lift Education Corporation, the Honorable Supreme Court, madam, clarified categorically, and they are having relied the decision of 2018, again 2021 also, my lord, reiterated, my lord. Even if someone who had acquired the education qualification in technical engineering through distance mode, and if they had a service, in that case, the Supreme Court held that categorically held that their service should be that if they have given promotion on basis of that should be cancelled, but whatever the monetary benefit he had acquired, that would not be returned. But so for service concern, if it's based on this,
So you are challenging this?
yes, my lord. Hence,
Mr. Tita Learned Counsel for the petitioners. Challenge made in this writ petition is to the office memorandum dated 06/05/2025. Passed by the commissioner within bracket PHE and WSD, bracket government of Arunachal Pradesh, whereby it is provided that the state government henceforth shall not recognize the diploma degree or postgraduate degree in the engineering obtained through distance education mode and produced by the government servants as the same are not recognized by the AICT, IGNO and DEC. Page 49, huh? Unless joint committee of the AICT, IGNO and DEC recognize the degree or diploma or postgraduate degree, accept such diploma degree or postgraduate degree in engineering through distance education, which is already accepted by the government. Distance education is not.
No, not acceptable, my lord.
Unless joint committee is already accepted by the government. They are talking about the joint committee.
And the joint committee,
If
my
the
lord,
joint committee of AICT recognizes, then only it will be.
my lord, my lord. But that part, the series of my lord, they have been clarified, my lord.
Mr. Next period, Tita submits that, learned concept by the petitioner submits that, since the diploma or degree or postgraduate degree in engineering obtained through distance education mode has already been de-recognized.
Yes, my lord, they recognized by the All India Council of Technical Education.
And de-recognized by the All India AICT.
Yes, ma'am.
AICT, comma. In the year since
My lord, since 13 March 2010, my lord.
13 March 2010 by notification, comma, the decision of the state government to not recognize the diploma or degree or postgraduate degree in engineering obtained through distance education mode. Henceforth, by the impute of his memorandum, is illegal and cannot be, is not sustainable. Please issue notice returnable by 4 weeks.
My lord.
As Mr. Estapin Leonard, senior government advocate, enters appearance and accepts notice on behalf of. Respond number, all the respondents.
All the
Respondents. No formal notice need be served. However, extra copies be furnished to the consent to the learners. Senior government advocate, huh? Furnished so and so, huh? But
those people have not been implicated in the
Yes.
party.
My lord, that is why, my lord, although it's not, but ultimately government has to make a call, my lord, final call. That's why, my lord, that is subject to their decision, government decision, but the government has arbitrarily taken decision, my lord. That's why, my lord, they are not done.
this promotion is 28 March 2025.
Yes, my lord.
It's not possible. Once it is de-recognized or it's not recognized, how can you base?
But it will directly affect them, lordship. So
So-
they are necessary party.
At least a representative whom you know, you just implement them.
My lord.
Paragraph 8
Page 48, you may implement.
My
You may specifically implement Mr. Ate.
my lord, I have an interim prayer, my lord. If my lord can, otherwise, my lord, make an observation, my lord, the pendency of this representation will not be barred to consider the. We have submitted representation on 6 June 2025, my lord, at page 20, page 50, my lord.
But you cannot, on the basis of this diploma and degree.
Lordship,
obtained through-
I have obtained RR this morning, lordship. In RR, it's silence, lordship, for promotion from J to A, lordship. Education qualifications is not applicable, lordship.
What is applicable?
Lordship, the length of service they serve in the lordship.
No education
It
qualification.
has to be promoted from J to A, lordship. Education qualification is not.
JE has to have some qualification.
That is their lordship. That is their.
My lord, the representation, my lord, make just observation, my lord, shall not be barred to the authority to consider a representation during.
It's a interim order is called for, I think. You cannot promote like this.
Right.
On the basis of the,
Lordship, without implementing The parties.
They're already promoted.
Pendency of the writ petition
Malad.
shall not be a bar for the authorities to consider the representation dated
6/6/2025.
6/6/2025 filed by the petitioners. Considering that the diploma, degree
Obtained through
and masters, what do you call it?
Master in Engineering. Malad.
We'll see. Page.
Page 49, Malad.
Considering that the diploma or degree or postgraduate degree in engineering obtained through distance education mode has already been is no longer recognized in terms of the AICT notification dated 13
March 2010.
2025.
13 March 2021.
But just indicating.
Malad. Deeply.
Hi, Lordship.
Yes.
I am a teacher, Lordship.
Hmm.
ATV teacher. This is with regard to this transparent posting issue.
Yes.
This case is kindly see, Lordship. I am alleging here is the arbitration is in the transfer order.
You are simply alleging.
And yes, that happened, and there is a malafide. Kindly see, my previous transfer order. I am a physically handicapped person too. And kindly see page number 35, annexure number 3.
Page.
Page number 35, annexure number 3. In this case, come down to serial number 9. It is RP30, the petitioner. His previous school is government primary school, Higapogu. And he has been posted to another village within the district at the government upper primary school, This order was issued on 26 May 2025 by the Deputy Director of School Education. Concerned. Then accordingly on 4th June, in the next page, page number 36, annexure 4.
Released.
Yes, he has
Then
been released.
you have joined.
Yes.
Then
And then page number 37, I have joined to the school.
it's okay.
Yes. Then in the meantime, page number 40, kindly see. Page number 40, annexure 7. This come down to serial number 13. This my name.
Okay,
is
common
also-
transfer order.
Yes, this
Huh?
transfer order,
Common transfer order.
common transfer order.
Hmm.
Yes. My name has been again listed here, is listed here. On June 18, 2000 and June 18 June 2025. And kindly see, my transfer has been, whereas I have been already released, and GPS nearing my school has been government primary school nearing, and this is not the school where I am staying, because I am already, there is no such school, government primary school nearing officially. It is government primary school.
Don't go into that. Why you are agreed by this?
Because kindly see.
From where you have been
Background-
transferred is not
back-
issue.
yes, Background fact behind the issue of this order.
Hmm.
This order. Kindly see, page number 39, annexure 7, annexure 6. Kindly see serial number 4. There was a resolution moved by the BJP, Bharatiya Janata Party, saying that
How you connect this?
because he participated on 6 June, he participated in this landowner meeting. Because there is a big dam is going to be constructed at Sia. That is going on. And about the meeting for public view, he expressed his opinion that he is not in favor of that. But on 39, page number 39, it was a third.
How you connect this? The decision of the BJP and your transfer order.
Because that is kindly see page number 4, page number 39, serial number 4. 35
It
only
will also appeal
only
to the
one
government, take
appeal
appropriate
to the
action against the
government.
person or any to be violating government.
appeal to
orders.
the government to take appropriate action against.
Where does it say that
government
it should be transferred?
Yes, government.
Where does it say that it should be transferred?
It should, exactly, it is not written, but it can be, inference can be drawn. That is one of the.
If everyone started drawing inference, what will happen?
That is,
It will be chaos.
yes, that is one of the factors.
You just saw that this is there is a resolution or the plea to the transfer these persons. One line, 2 words.
It is, this honorable court may draw inference.
No,
It is-
we cannot draw
And
inference.
another fact, another ground by which I am coming here is, can you see? here
It's
is
a common transfer. There is nothing.
No.
Heard Mr.
can
P.
you see-
Tapak, London Council for the petition.
Can you see this, as per the Education Act,
Hmm.
this, can you see my paragraph is specific government, yes, page number 17, para number 13. As per the Arunachal Pradesh Education Rule 2010, generally, the teachers should not be.
You are the only one.
transferred in
You are the
mid of-
only one before this court.
Yes, mid of the academic session. And in that case, if mid of the academic session, in that case, if the teacher is to be transferred, reasons has to be recorded and it should be under exceptional case. It is a previous transfer it was a from village to village within the district. And this is a district transfer from Siang district to Karadadi district. And being a lame person, or disabled person, he cannot move easily in an uneven area. And he is a disabled person, he requires assistance from the family. And he is ATV too. As ATV, this, your lordship is aware that this is a post of ATV, +10%. And one of there are 3 conditions given in the guidelines, not guidelines, it's ordinance for this Education Rule 2010. This is mid of the academic session, the teacher should not be transferred and it should be minimized. And another is the physically handicapped person. It should not be minimized.
Where's the rule?
authority should
Where's the rule?
Rule is here.
My lord, it's not a mid of academic session, my lord. Rather, it is the right time to effect the transfer posting, my lord. As per transfer posting calendar, my lord. And my lord, impugn order itself, the region is very clear, my lord. It's a region noted at page 41. These note, my lord.
Complete the submission, ma'am. This, as per the rule, physically handicapped person, kindly see the rule 52D. Physically, the authorities should minimize this transparent posting of the physically handicapped person. Rule 52D. Rule 52D. I am quoting the Rule 51A, Rule 52D, and Rule 52G. As per the Rule 52D, physically handicapped person should be transfer of such employee who are physically disabled should be minimized by the authority. And another is the person who has already attained the 55 years of age. That should also be minimized. And apart from that, there is already standing guidelines of the government. As per the government, this standing guideline, it should be as per this, kindly see, page number 54. The transfer should be effected before the onset of the monsoon and after the school examination of their children is over. Accordingly, I was transferred as per the earlier order. My previous transfer is lordship.
What is this?
In the May.
It's a rule or act?
This is the rule. There is already act. In support of the act, there is a rule.
It says only minimize.
Yes,
It
minimum,
doesn't bar,
not bar.
it doesn't bar
Since-
any transfer and posting.
Since lordship within 1 month, again, press transfer has been issued and showing that I should be transferred from the previous school. whereas I
see,
have
we'll
already
issue
joined.
notice.
This is the issue.
This is of 23rd June. It should be released within 10 days. Nothing doing. And Mr.
I am
T.
a
Tapak,
visible person of
learned
it.
counsel for the
Kindly.
petitioner. The challenge made in this writ petition is to the transfer and posting order dated 18/06/2025 issued by the Commissioner within Education Bracket Clause, whereby as many as what is the next one is what?
Lordship,
Modification. 22 PRT and TGT as well as another 5 PGT and TGT teachers and have been transferred and posted to various schools. Mr. It is the contention of the petitioner. It is the contention of Mr. T. Tapak, learned counsel for the petitioner, that the petitioner is sought to be transferred. Uses in 11, no, 22 and another 5 PGT and TGT also have been transferred, including the petitioner. The Mr. Petitioner is sought to is transferred from GPS Nyering, Siang district to Karadadi district at the disposal of DDSC Karadadi. Mr. Then you write, it is the contention of Mr. Tita Pagalan, counsel for the petitioner, that the petitioner is sought to be transferred only at the behest of the Mandal coordination. Mandal, what is that?
It is a mandal, it is the meeting resolution. It is a mandal president.
35 Pangin BJP Mandal. Who has passed a resolution for taking action against the government employees who has involved in the incident of mob lynching attempt upon the local MLA, Mr. Local MLA and the minister in the government of Arunachal Pradesh. He submits that the petitioner, being a landowner, was just a mere participant in the meeting of the landowners and were not involved in any kind of illegal activities. Mr. The petitioner is also an physically disabled person and is of about 56 years.
it is 56.
You,
Yes.
You?
Actually, I'm the first generation, this, still.
I'm asking something, you are making
It is
unnecessary.
57 now,
Hmm.
running.
Is more than 56 years. List of, he submits that in view of the, as per the, what is rule?
There is.
Rule of what?
Education rule, Arunachal Pradesh.
Show us the name of the rule.
This is, can you see, Arunachal Pradesh, Education Rule 2010. Arunachal Pradesh Education Act is there and rule is there, followed by rule 2010.
According to him, as per the Arunachal Pradesh Education Rules 2010, frame under section 141 of Arunachal Pradesh Education Act 2010. Where is this page?
Page 17, paragraph 13.
Rule 52. Reverse the minimization of the transfer of teachers. Which provides that the transfer of teacher from one district to another district shall be minimized, except the surplus teacher in a district who may be transferred or redeployed in a needy school in another district. However, relaxation shall be given in the following cases. Relaxation will be given in cases E and G, E dot G. Example, a teacher, where a teacher is physically handicapped or disabled, and where a teacher has attained the age of 55 years. List of, he submits that the, in view of the above rules, the petitioner being a physically handicapped person, and then as I said, about more than 56 years, the transfer of the petitioner to another district is in violation of the above rules, in violation of the rules, provisions of the rules. Mr. Tapak further submits that the petitioner was transferred page 43 is your first transfer.
Yes,
Huh?
first transfer.
No. Where it is?
Not 35.
Huh?
Page 35, annexed 3. Within a month, I have been transferred twice.
Further submits that apart from the above,
Page number
of the
35.
petitioner,
Annexed 3.
page 30,
35, annexed 3. It is serial number 8.
was transferred from government. What is PS?
Primary. teacher.
PS Riga Mobuk
This is PS primary
to
Rigamo.
government UPS Dite Dime only
Upper
on
primary
26/05/2025. Therefore, the transfer of the petitioner within a period of and not within less than a month cannot be sustained as there is no public interest involved. That too, showing the petitioner to be transferred from GPS nearing Siang district rather than government UPS Dite Dime. if he submits that the transfer order is not sustainable and they may be state for and accordingly and the impugn order may be state pending the return of notice. Issue notice to the respondents as Mr. So and so, both of them. No private respondents.
Private respondent is, there is.
There is a
no-
private
No
respondent.
replacing teacher, no private respondent.
Huh?
Except respondent is, I've made a respondent to this.
Private respondent 7 is,
Private respondent is here, not the teacher, but.
Then
and 6
one-
also there, my lord.
1, 2, 3, 4, and 5, huh? No formal notice need be sent.
Two private.
Entered
respondent is-
entered appearance and accepts notice on behalf of respondent number 1, 2, 3, 4, and 5, huh? No formal notice need be sent. Petitioners
you'll
to
be
take his
getting
case for
back, no?
service of notice.
Madam,
6
5,
and 7 for.
5.
That's why I said
madam.
both 1 to 5. To take his steps for service of notice upon response 6 and 7. What do you say this? You'll have to minimize as per the rule.
That is right, my lord. My lord, the earlier transfer, my lord, it was within the district only, the shifting of the school only. So present transfer, my lord, it is on need based, my lord, on administrative exigency, my lord. There's because where even if they are posted where there's no requirement of teacher, my lord, that will not be the interest of the department, my lord. Therefore, having seen to rationalize, my lord, that has been posted to the place, the school where there's acute shortage of teacher, my lord, as per the reason given in the impugn order.
Mr. T. Thagum, Land Council for the Land Standings of Education Department submits that by the transparent by the impugn transfer and order dated 18/02/2005. No, the impugn transfer order, transfer and posting order is a common transfer order, and they are being transferred based on administrative exigencies and on need basis to schools facing acute shortages of teachers and upon completion of their normal tenure at their current place of posting. Mr. The transfer and posting, the petitioner has failed to show the link between the resolution of the BJP Mandal of Pangin and the transfer and posting, as the resolution of the BJP Mandal of Pangin has nothing to do with the transfer and posting. Rather, same has been issued purely on administrative exigencies. Mr. Anything else?
My lord, now that by this time, my lord, he must have released, my lord. This has to be all the posted, transferred. The teacher has to be released within 10 days, my lord. Now today it was.
Considering next paragraph. Considering that the rule provides for minimization of transfer from one district to another, particularly Rule 52 of Arunachal Pradesh so and so, Education Rules so and so, 2010. Where the teachers or the persons employees are physically handicapped, and where the employees has attend, with the teachers, you just, right, teachers is physically handicapped and attained the age of 55 years. Comma. And considering that the petitioner has been is so to be transferred from one district to another. And that within a period of less than to less than a month from the last date of his posting, transfer and posting. Comma. In the interim, it is provided that no. It is provided that till returnable that the petitioner may not be released if already not released.
Mal.
Why not staying? If already not released.
Deeply applied.
Lordship, transfer posting matter, Lordship.
Yes.
Lordship, here, Lordship, impugn order is at page number 27, Lordship, edited by Lordship. Married, Lordship.
Yes.
He, in the interest of public service, Governor of Arunachal Pradesh is pleased to allow so and so J. Ligang as in charge assistant engineer PhD and WS subdivisions Madhepur till posting of regular assistant engineers with immediate effect. Further, the Governor of Arunachal Pradesh is pleased to order the retention of ER so and so petitioner assistant engineer PhD WS subdivision Tunkura under PhD WS divisions till further order, Lordship. Lordship. Here, Lordship, private respondent, Lordship, holding the post of J, Lordship, as a initial, Lordship. Here, Lordship, private respondent not holding the similarly situated officers in the department, Lordship. He replaced the petitioner, Lordship. And Lordship, earlier transfer posting order, Lordship. The annexure 1, Lordship.
No, you have been retained.
Retain, Lordship. Retain
Not in your place.
in Lordship. I am Lordship. Can Ferus Ferus annexure 1 then only understand, Lordship. Lordship.
I have understood
Yes,
everything.
Lordship. Lordship, I am retained here.
Yes.
Still, Lordship.
You
I
want to go to
join.
Madhepur
Yes, I am.
as per the earlier posting.
Yes, Lordship.
So
And
what?
I join, Lordship. I'm joined the I'm joined there, Lordship. Madhepur, I join, Lordship. And drawn the salary also, Lordship. But in this petition, Lordship, I could not enclose, Lordship, due to non-providing of any the documents, and especially, Lordship, salary statement, Lordship. I have a copy, Lordship, but not enclosed in here, Lordship. And release order is there, Lordship. I join, Lordship.
Where is the earlier transfer?
Earlier transfer order, annexure 1, Lordship. Page number 22, Lordship. Mary, Lordship. In the interest of public service, Governor of Arunachal Pradesh is pleased to order the transfer and posting under the mentioned assistant engineers under PhD.
Sunpura to
Yes, Lordship.
Madhepur.
Yes, Lordship.
Yes, then
Then, Lordship, I join, Lordship. Release, Lordship. Release.
what is next page is what?
Next page is, Lordship. That is regular, Lordship. I am regular assistant engineer, Lordship. Showing I am a regular assistant engineer, Lordship. This is annexure 2 is showing that I am regular engineer. And annexure, Lordship, 3, Lordship. This is joining, Lordship. Release order is also here, Lordship. Release on the petitioner was released on 5th April 2024, 25, Lordship. And on the same day, Lordship, afternoon, Lordship.
How long this respondent was serving?
Lordship, respondent is that this order is issued, Lordship. Impugn order is issued on, Lordship, 26 lordship, 26 May 2025 lordship.
Hmm.
But lordship, I could not, the petitioners not got this impugned order lordship.
In your place, one Bamja Madhu was
Yes, lordship.
posted.
Yes, lordship.
What happened to him?
Lordship, that instructions, lordship, I have no instruction. But I joined and draw the salary so that lordship, and still I am not released by the executive engineer lordships, NAMSI lordships, under whom
Yes.
I am working.
Lordship,
Look
I,
at this, this is between one, the Bamja Madhu.
yes,
So he has been posted as Sunpura.
yes,
All right.
yes.
If he is retained, where this man will go?
Lordship, by motive, Lordship, this is, item number 6 is offshoot of this petition, Lordship.
Item number 6.
6, which is, because I'm appraising this no code law because because this
So this the petitioner is a diploma
diploma.
from distance education board.
Their claim,
So, because
we are promotees lordship for
Yeah, but then you are,
because he has been
third year lordship.
you
We
are,
are
you are
promotees.
therefore he has challenged you to
yes, forget about the transfer posting. Your
Yes, lordship.
the Democrat sword are hanging on a bush.
Even
As
lordship,
a,
still
regarding
that order is not put
to
to
the
challenge.
status of your assistant engineer.
This order is not put to challenge lordship. It's still not put into challenge lordship.
I know.
My
I
promotion order.
As learned senior government advisor has pointed out, just appraised, item number 6.
Yes.
Forget about transfer posting. Be concentrated on your distance mode.
Lordship, this is the lordship.
anyway, Lordship,
I think it's
The transfer,
you will
Lordship,
have to you will have to state this.
order was issued on Lordship 26 November 2024, Lordship.
Lordship,
The petitioner did not join at Mahadevpur, Lordship.
lordship, join lordship.
Kindly come to
I
page
saw lordship.
When did
25.
you join?
Yes,
25 losses. In the month of
April,
April losses, though order was passed in month of November 2024, in the month of lordship April, on the 5th April, he said he has joined lordship. Lordship will find there's nothing lordship request received on behalf of the authority.
Lordship, I also lordship. I
This
have
morning I have spoken to the transferring authority. I have been told that he has not joined their
I have a loose sheet lordship.
Mahadevpur. Therefore,
I will.
Therefore, the present order has been issued. That is the lordship what I have.
Since he has not
This is joining.
No, he has not been joined. So therefore, this order has been issued.
Lordship, this is joining.
That is just lordship what I have been told verbally lordship.
Joining, and I drawn the salary of 3 months from WS division NAMSI lordship.
no, where your joining report is in the month of April. From
Lordship.
April you are drawing.
Lordship, I was not released lordship.
Okay.
Not released by my concern controlling officer lordship, executive engineers. Executive engineers lordship raised only on in 5th April lordship. So lordship, this is the reason
Actually, that
lordship,
is not the
why I
part
not
here.
join lordship. Lordship, I statement is made.
For the purpose of interim only.
Lost no issue.
Just keep it. Heard Miss Jeevam, learned counsel for the petitioner. Challenge made in this petition is to the order dated 26/05/2025. Passed by the Commissioner, PHE and WS. Government of Arunachal Pradesh. However, the petition is sought to be is retained as a steam engineer. PHE and WS subdivision Sunpura. Comma, Teju. And the respondent number
Respondent number 3,
3
private respondent 3.
has been allowed to, is sought to be allowed. Respondent number 3, junior engineer, Lekhan, as in charge assistant engineer of PHE and WS subdivision, Mahadevpur. Till posting of the regular assistant engineer. Please do. The next paragraph. It is the contention of the petitioner that he was from PHE WS subdivision from Sunpura to PHE and WS subdivision Mahadevpur by the order dated 26/11/2024. Mr. However, he could finally join on 05/20/25 as he was not released by the authority. It is contended that it is further contended that the imperial order has been passed only to accommodate the respondability, which would not be permissible as the petitioner is the regular assistant engineer and he cannot be posted. And the officer who is lower in rank cannot be posted in the higher post when the regular assistant engineer is serving. More so, that too, when the petitioner has just joined on 05/04/2025 without there being any public interest or administrative exigencies. Issue notice returnable by 4 weeks, as since Mr. Estafil Senior enters appearance on behalf of respondent 1 and 2, no formal notice in this however extra copies to answer. Petitioners to take a stage for service of notice after respondent number 3 by register post to answer. Are the parties on interim prayer? Hard on interim prayer, huh? Mr. Next one. Having considered that the petitioner is a regular assistant engineer who has been recently posted at PHE and WS subdivision Mahadevpur by the order dated 24/11. What is that first order?
Imperial order, Lordship.
28/11/2025. Being joined on 05/04/2025. And the respondent number 2, respondent number 3, who is a junior engineer, were being allowed to hold the charge as an assistant engineer. It is provided that until the returnable date, the imperial order dated 26/05/2025 shall remain suspended.
Lordship, small correction, Lordship. This private respondent has not been posted as a assistant engineer there, Lordship, in his place, but he is already serving there J. Likhan, Lordship. He has
Place, I didn't say that. He has been allowed to hold the
Allowed.
charge of assistant engineer at Mahadevpur, right?
Lordship.
When he has already joined. So he'll remain, he'll not be affected. He was allowed to hold the charge,
Lordship.
all right?
Yes. Yes, then it's
Only that it has been, he will remain as a junior engineer at Mahadevpur. So there's no,
no,
I
yeah,
think,
then it's okay.
yes. Next. Yes,
May I, Lordship? Lordship, counsel for the matter is engaged in court number 2. So kindly may.
yes.
So what am I-
What is the instruction?
I, Lord, my senior Kakotis, Api Kakotis, the
Hmm.
is OPC.
Wait with your lordship.
Yes,
But the certain things in this matter are a matter of records which cannot be denied. That the lady who lodged the complaint, a lady student, she had unconditionally withdrawn the complaint. After that, the NIT authority has allowed him to appear in the examination, 7th and 8th semester examinations. Considering all these facts, because his career was also a matter of concern, he appeared in the examinations. Now he wants the results and mark sheets, etc. The problem with us is that we have, considering all aspects, not to so that his career will not be anyway damaged, we have allowed him to appear in the examinations. But problem is that the Senate is the highest body in with regard to academic matters of the institute. Senate in its meeting held on February 2025 has stated, Lordship, I just read out the language. Registration will be on hold until the matter is not resolved in court. Because the case, criminal case is pending in the court, which is lodged by affairs lodged by the lady. Subsequently, she withdrawn the complaint before the authority. That is a different question. But because of this finding of the Senate, we are handicapped to declare the result. Secondly, a criminal case is also pending under section 75, 78, 79 of BNS.
okay. Where is your the guidelines, regulations? Is there any provision that once the criminal case is pending, you cannot declare the result?
No, that is
What is
of
this?
course that is of course not there.
Yes.
Regulations
What is
doesn't
this?
say.
Or maybe just instruction from the department.
What is the instruction? Complaint against CDNZL. Why you cannot declare the result and provide the mark sheet?
That your because of the
You know,
Senate's-
sir. You know, sir. Until proven guilty, he cannot be penalized.
we are all for the interest of the student, but we are handicapped by two things. One is that criminal case is pending. We do not know what to do now. Secondly, the Senate had taken the decision that until the criminal case is decided,
That cannot be.
we
That means you'll
We have
destroy
many-
the life of the people before the conviction. That is worse than the conviction. It will be worse than the conviction.
that that issue I am leaving to Lordship's considerations. But otherwise, we have been quite thankful about that student's career. That's why you have allowed him to appear in examinations. In spite of
That will
Senate's
take care.
opposition.
This court will take the appropriate court will take care of that. But what is your regulation? What is your regulation? Which
Regulation is
bars
at the
you
moment
from
not
declaring the result and then issuance of certificates?
No. Once a student appear in the examinations,
You cannot spoil like this.
result has to be declared. But these are two handicaps the Lordship will decide our difficulties. Otherwise, we're all for the student's career. We simply
We're fixing it on 21st. Sir, it's very difficult through BC also. BC is also difficult. We're fixing it on 21st. I'll direct you to file the affidavit. Then please you join physically so that matter can be disposed of. Let us do that. It's very difficult.
Lordship,
They are
I-
just saying just because of I'm not able to get it. Just because there's a serious complaint against you, they have decided not to declare that.
That part we are not
That is
disputing,
very
Lordship.
difficult. So let them put on record.
The problem here is, Lordship,
Let them put on record, sir.
that part I agree, Lordship.
Huh.
But I have some difficulties here, Lordship.
Hmm.
Lordship, I have to take admission in IIT, Lordship, for pursuing my further PhD, Lordship. I've been selected, Lordship.
Ah,
The last date, Lordship, may kindly come to page 56, Lordship. Last date of withdrawal of that program is on July 14. It's nearing, Lordship. So I have to furnish all those documents before this date, Lordship.
page?
Page 56, Lordship. Withdrawn from the program, Lordship. The last date of withdrawn from the program with rupees so much only is July 14, 2025, Lordship. Now, if I don't submit all those mark sheets and transcripts and all, Lordship, that will be deemed that I withdraw from the program, Lordship. So may kindly, Lordship, may direct to.
Sir, 1 minute. Let me just see.
Yes,
Lordship, kindly permit me to place para 15 again. It says that Lordship, a critical and
para
immediate
15 of what?
of the writ petition, Lordship.
His petition.
Writ petition. It said last date is October 7, 2025. I read out the Lordship, but may I read out the entire
Yes.
para, Lordship. Lordship. The arbitrary withdrawing the petitioner's academic documents is causing severe difficulties for his further study and career growth. The petitioner has received a provisional PhD admission offer from IIT Kanpur for semester 1, academic year 2025-26. In substantial energy and substances. The offer letter from IIT Kanpur explicitly mandates the submission of crucial documents, degree certificate, provisional degree certificate, mark sheet, grade card, and qualifying examinations. A critical and imminent deadline has been stipulated. If the final result is awaited, these documents must be submitted by October 7th, 2025. Failure to submit by this date will result in the submission of being cancelled for immediate year. So we have still time till October, we have submit the final documents. Lordship has very rightly fixed it on 21st of July. By this time, we'll file the affidavit and the whole picture will be clear. No prejudice will cause to the petition if the case is taken up on 21st of July. And we are given an opportunity to file our affidavit.
October
Therefore,
7. I think this
Lordship.
withdrawal which you have shown is something like bank details. It's a bank details. Withdrawal from the program.
Showing wrong document. This is
It's a bank details only.
Program means, Lordship, the PhD, Lordship. This is continuation of the letter that was furnished to me, Lordship.
PhD
Starting
or
from page 54,
at
Lordship.
IIT Kanpur.
Lordship, starting for page 54, Lordship.
Huh?
Provisional admission to PhD program semester 1, 2025-2026, Lordship.
Please.
54.
Imminent, the critical imminent deadline is if the final result is awaited, these documents must be submitted by October 7, 2025. It's your own statement.
Lordship, second paragraph of the letter, Lordship, you are required to upload the following documents on the document submission portal during July 22, August 2020. Dates are tentative and subject to change, Lordship. That date can be changed at any point.
It's okay, but then you are on your bed. This is, you see, it's very difficult. Number one, I'm not able to understand. So it's not clear because of the BC. I could only understand just because there is a criminal case, the result has been result. He has referred something. So we'll tell them, we'll direct them to file the affidavit on or before 21st. During vacation, sir, during vacation, you have to.
Yeah, we shall certainly do it, Lordship.
And we'll fix it on 21st. There's
Your
an
Lordship.
urgency. I mean, you cannot spoil the life of the students.
I certainly agree with your lordship.
You advise the authority there, NIT authority.
I'll do it.
There's
your
no
lordship.
rule, there's no regulation as such. When there is a criminal case pending, you cannot declare the result.
Lordship, yes.
We're not saying since the criminal case will take time, we're not saying that it's not a serious matter, it's a serious matter. But balance has to be there.
I quite agree with your lordship. So we'll
Hi,
file evidence,
Mr.
lordship.
Judge, learned counsel for the petitioner. And also heard Mr.
RP Kakoti. lordship.
RP Kakoti, learned senior counsel assisted by
G. Lawrence.
G. Lawrence, learned standing counsel for the NIT AP.
Yes.
And Mr.
Ensura.
Ensura.
Correspondent number
Appearing on me, Mr. M. Kato, learned DSA. Correspondent number?
1.
1. Next, on considering the urgency of the matter, this court has directed the respondents to place the instruction by an order dated 30/06/2024. However, today, Mr. RP Kakoti, learned senior counsel, appearing through virtual mode, submits that he may be granted a week's time to 10 days time to file affidavit of opposition. List of considering having accordingly a 10 days time is granted to the respondent authorities to file their respective affidavit in opposition. Mr. Has agreed to with learned counsel for the parties, let this matter be listed on 21/07/2025. Mr. Before that, you write the writ petition is filed praying for so and so. It's here, huh? Last order. Issue notice so and so. Huh? Issue notice same moment. Then today this court so and so. Huh? That will be letter. You write this direction respondent to declare the petition results so and so. Huh? Issue notice so and so. Then you write all those things. Ensure that it is filed before, on or before 21st, so that it can be disposed of.
Yes, it will certainly done.
Endeavors shall be made.
That's like the
It will certainly
endeavors shall be made to dispose of the matter on the next date.
Oblige, your lordship.
Oblige.
Deeply oblige.
Yes,
May I please, your lordship?
Mr. Kautil, what is to be done?
Request for filing of list of witnesses, lordship.
Hmm?
List of witnesses, lordship. And
Ah,
I was filed in the morning also. It
I-
is arrived.
IA for what?
I am calling for documents, lordship.
Where?
Has it arrived?
Well, item number 10, we have filed a Mr. Senior Counsel PK Tiwari will appear online.
Yes, sir.
Now, my lord,
Sir,
today
you
was
know the
date for-
difficulties and you are still enjoying at Guwahati.
My lord, my lord, I wish I could enjoy at this moment. But my lord, certainly not. Immediately after vacation, certainly, I'll be appearing
Yes.
physically. Now, my lord, today was a date fixed for the list of witnesses. So
Yes.
our list of witnesses is ready, but I think it should be filed together by both the parties. I do not
No, we
know
have filed.
whether the election petitioner is filing the list of witnesses. That's
We have
one.
filed it.
Very well. In that case, our list of witnesses would also be there, my lord, this morning. Now, my lord, there is another aspect. So far as the IA of the election petitioner is concerned, which is under Rule 93, if I'm correctly given to understand, though I haven't seen it as yet, you know, that needs application of mind. Because unless and until I apply my mind to it, it's very difficult.
No, what is
I
this?
may not.
What is this IA again?
My
My lord,
lord,
there is one.
if may I submit, lord? My lord, what is it, my lord? My lord remembers the order dated 22/0/2024 passed in Annexure A, lordship. Annexure A, dear lordship, we had asked for preserving the documents relating to the election, lordship. Then this honorable court was pleased to direct the concerned officers to authorities to preserve those documents, lordship. Thereafter, lordship, we had filed an IA number 54, Annexure B, lordship, wherein we had sought these documents that we may be allowed to inspect those documents and thereafter get copies thereof, lordship. Now, if lordship comes to paragraph 43 at page 45, lordship, the IA.
40
page 45, lordship, paragraph 43
of what?
of the IA, lordship.
IA of what? IA 181.
Not 181, lordship.
181 has been filed by the
Well,
respondent.
181
Huh?
is mine. My lord, 181
Two
my lord,
IAs have been
by
filed
us.
to the lordship.
180, please, for a moment. 181 has been filed by us. Lordship may see 181 for a moment first. 181.
We have fixed it for today. We have fixed it for
Lordship may kindly have a look at
submission of list of witness.
yeah,
We are
list of
filing one
witnesses
after
are there.
another. What is this?
We have filed a list
That's
of
fine.
witnesses, lordship. If lordship,
List of
lordship,
witnesses are there before the honorable court. The only small clarification, my lord, IA 181 is for the purpose of reframing the issue number 7. Now, my lord, this is an application under Order 14, Rule 5, because Order 14, Rule 5 permits the honorable court to amend or restructure the issue. The issue number 7 may kindly be seen for a moment, my lord, just to bring in the clarity in the issue number 7.
No, we'll hear there some other day. IAs will be heard some other day.
Very well, my lord. Then could it be, my lord?
It's very difficult. You don't want
yes.
to move the matter.
Very well, very well, very well.
Cannot
The only
stop
thing
the-
we
let them file it.
we
If they have any
cannot stop
objection, let them file.
the parties also were not able to proceed substantially. Heard Mr.
DJ Kapil, lordship.
DJ Kapil, learned counsel. Let it be on record. We'll next date we'll consider everything.
Very well, my lord. Then could it be on 31st of July? It
What
can't
would
be
be the
before
next?
31st of July.
He is submitting.
It
Tell
can't be
us,
before
you have, today you have filed a list of witnesses.
Yes.
Next date will be for what?
My lord, next day for consideration of the interlocutory applications.
In the meantime, we have
Really,
Because there
We
are
will
two
not be able
IAs.
to complete. Sir, I think in that in this manner will not be able to. We cannot stop it also.
Actually, it
In
should have been
manner will
not-
not be able to complete
in an
even after
election-
5 years.
Filing of
My
evidence,
lord, in
lordship,
an
but that's why
election
the IA.
petition,
lordship.
in an election petition, my lord, one can't help it. There are, my lord, contingencies, and certainly the situation is such wherein such IAs have to be there, my lord. One can't help it.
Heard, Mr. I
Let
know,
it be,
but
my
then
lord.
that's what I'm saying.
My lord,
Can't help
it
it.
happens in the election petition.
Heard Mr. DJ Kapil, learned counsel for the petitioner, election petitioner, and also heard Mr. PK Tiwari, learned senior counsel, assisted by Mr. Al Tingon for respondent number. One
sole responsibility.
respondent, sole respondent, oblique return candidate. List of parties have filed the list of witnesses, which is taken on record.
Yes.
Right? List the matter. On when? Let us give a
My lord,
fixed date.
couldn't be- it should not
Huh?
be before 31st of July. It should not be before 31st of July. 31st of July will suit me.
1st of August.
1st of
Oh,
August.
yes. Yes, 1st of
1st
August
of
also it
August.
could be. Yes, all
It's a
right.
Friday.
For what?
For
Lordship.
First
consideration
of
of
August for
interlocutory,
what?
for interlocutory applications. For
No, we can, in case, had you not filed this, we could have proceeded with the evidence.
Yes,
Lord,
Lord.
but
On the
it- but
next.
the interlocutory application will have to
Then
be
we'll not say
considered.
anything. It's taken on record.
Very well, very well. Let it be IA.
okay.
All
Let
right,
it
all
be.
right.
With an understanding that we'll be taken up the IS on the
And
day.
if need be, my lord, if need be, I may file my objection in their interlocutory application.
You have received it. No?
Yes, we have.
We'll not say anything, you do it.
Very
All
well,
right.
very well. Very well, very well.
Okay. 31st, huh?
1st of August.
1st of
First of
August.
August. First of
Yes.
August. All right.
Fine request.
Next time I request,
I'll be, my lord, I'll be there physically.
please let us have the matter physically.
Yes.
Actually, Lordship,
Virtual is very difficult.
Provided, my lord is
I'll-
also
I'll-
there in the Itanagar.
Sir, you might have seen the last case. It's a
Oh,
very,
yes,
very
I saw
urgent
it.
matter because
Yes,
of the BC. I could not.
Yes,
Of course,
I
they have
know.
not
My lord, it is
brought
under,
a
it is
proper
under compulsion.
obstruction.
My
In
lord
fact,
knows
Lordship,
by nature. It is,
our IA is aimed at expediting the matter only, Lordship. Once our IA is taken, the matter will be expedited, Lordship.
Okay.
Highly
the only
request.
issue, my
First
lord,
we'll say.
the only issue would be whether my lord will be there in Itanagar on 1st of August. If my lord is not there in the Itanagar, it will be BC
But
only.
then, because of the roster also, you cannot,
Probably, my
we'll
lord.
see.
Yes, very
We'll see.
difficult. Very difficult.
Yes.
If my lord is in
If it
Guwahati,
is-
nothing like it.
If it is not for evidence, from anywhere I can take up.
Yes.
You
Yes,
can take
yes,
up the
certainly.
matter from any bench
Hopefully-
and any
Hopefully, my
Yes.
lord will be either in Guwahati or in Itanagar.
party only.
Very good.
Highly obliged.
Yes. Yes. What is this?
May I, Lordship?
Hmm.
Lordship, in this matter, paper book has been not prepared by the registry.
Huh?
In this matter, Lordship, paper book has been not prepared by the registry. So, Your Honor,
Decision has not been received. We'll
yes,
say. Decision, what this criminal appeal?
yes,
After the receipt of teacher only the paper.
Hmm?
but
Scan copy
but
of the
Lordship,
records of the special NBS case arising out of a call from the special judge. We have called for the scan copy. Why a scan copy? Huh? Call for the tripod. Why they have seen the scan copy? Yes. Why scan copy has been called when the trial records has been called?
Yes, record should be.
It's an appeal only.
Yes, appeal only.
Against the conviction.
Yes, this.
Look at this. Let the scan copy, original record. Office note. Huh? Call for the tripod record. Office note 0307-2025 indicates that the trial court record is yet to be received. Registry to send reminders for the original trial court records, not the scanned copy of the records.
Lordship, one IA has also been filed with the criminal appeal. So,
Ah.
I may be listed after the summer vacation.
Obviously, your record is name heard Mr. Swenson
GG.
for appellant and Mr. Deloy for PP, London PP for respondent. Huh? Then you write down. This is the matter after 4 weeks. 4 weeks.
Your Honor, 4 weeks will be too long.
3 weeks. 3 weeks.
3 weeks
Okay.
enough.
Next.
Most obliged.
Your Lordship, here in this case, service has been completed,
Ah.
which may be kindly recorded, and the matter may be fixed.
It is so voluminous. Hmm?
This is civil division petition, Your Lordship. So here all the lower courts documents has been
Service complete.
Yes, service has been completed. So next
Yeah,
maybe
Your Lordship, if Your Lordship may refer to order dated 12 July 2025.
Your Lordship, this honorable court had already passed an order that matter may be fixed for 12/8/2025 for admission. The order has been already passed.
Why this has been listed again? 12/8. IA is for what? Maybe because of the IA.
No, no,
No,
there is no IA.
This is item number 13.
The 13.
Okay, 13.
Yes, yes. Next maybe fixed.
This has been,
Your Lordship, actually, there was a mention made yesterday in court number 2
for what?
that matter may be listed for today. Maybe because of that, it has been listed today.
List in order column, service completed. Fixed for hearing.
Lordship, in that case, that order may be remain as it is. That order may be remain as it is, fixed for admission hearing on the next date, on 12th of August. This
So
is
why you have mentioned it? Who has mentioned it?
yesterday, actually, your Lordship, this order was not uploaded yesterday. This order was uploaded this morning. So we didn't knew we didn't update it.
This matter was listed on second.
Second, yes,
And
yes.
Due to paucity of time, I don't think, it was not taken up due to paucity of time.
Yes.
No, it said that it should be listed on 12th of August.
Yes, yes. Then your Lordship, that order may be remain as it is. Kindly.
Why you have mentioned this?
Lordship, this order has been
Was not uploaded.
uploaded, yeah. It was uploaded this morning only. So we were not informed. We were not updated.
Okay. Mr.
M. Kambu.
and M. Kambo, learned counsel for the petitioner, submits that the matter has been mentioned as there is no order for listing of the matter, fixing listing of the matter. However, it is seen that the matter is already fixed for 12th of
August.
12/08/2024. In view of above, that this matter will be listed as fixed, as ordered on 02/07/22. On and listed on 12/8/2020. Mr. Jaisri and Mr. Disoki, the responsible respondents are present. Okay. This for what?
May I please share, Your Lordship?
Yes.
This is for the IA case for the vacation of the interim order, which is by this honorable court on dated 26/6/2025, which is enclosed in my petition, Your Honor. A1 series, page number 19 to 23, especially page number 23, Your Lordship. May I?
What is this?
Yes, in the last point, the honorable.
Notice what is this?
The last part of the order strictly said that in the view of said deed of agreement, the court in the interim direct that the further proceeding of FIR dated 19/3/25 be a stay till the returnable date. My lord, this case, criminal petition case 136/25 is heard in the motion stage without the heart of the opposite party. First point. Second point.
What is the matter?
Matter to set aside and quashing the FIR proceeding, Your Honor, which is still going on the investigation part before the Nahalaga police station. Regarding the criminal breach of trust, cheating, common intention, and fraud, Your Honor, my lord. So in that connection, I'm not any.
You are a party?
Yes, I'm the party, Your Honor, my
In the
lord.
criminal petition?
Yes. Number 2. Respondent number 2.
Will issue notice.
But my
same thing will happen.
But my lord,
You said without hearing you,
Yes.
this interim order was passed. Again, how can we pass and hear the vacation
at least whatever the stay order is there,
without hearing them again?
Exactly, my lord. Because it is a,
So we'll not commit a same mistake. Let us rectify. You
But-
said
yes, yes, my lord.
that you are not heard.
Not heard,
When is
not give
it-
opportunity.
Now you want me to hear without hearing, we want me to hear, pass the order without hearing them.
At least whatever, my lord, it's my humble prayer, this honorable court, that at least whatever the till that, this order
See,
not
court has
accepted.
filed wrongly or rightly, just cannot simply back it like this.
But
There is
it-
an agreement. It
That's true.
appears to be more of a civil, purely of a civil nature.
Not, your honor. Because there is so many ingredients, so many prima facie case established
See,
against the
it will
opposite
be
party.
the subject matter of this criminal petition.
Criminal petition. That's
It's
true.
the
The-
subject matter. But prima facie court finds that there's an agreement and all these things is more of a civil nature. So
My lord, this case is not in charge sheet yet, till the investigation going on.
yes.
And the investigation authority is clearly stated it is a pure criminal case. That's why the investigation going on.
Investigation should not be.
So, my lord,
Normally, I agree. Normally, investigation should not be. Inquiry and investigation should not be stalled.
My lord, I'm the counsel of petitioners, my lord.
Okay.
My lord,
So
as
you
of
are
now-
already here.
Yes, my lord. My lord, as of now, I have received the IA from the opposite parties.
Okay.
Therefore, I needed time to go through for filing reply IA, my lord.
Now I'll hear. You
Yes.
are there.
Yes,
Okay.
yes, my
Are you ready?
No, my lord, I'm not well versed.
You should not have appeared. I was indicating him that without hearing you,
Yes,
I cannot pass the order. Since you are there, we'll hear him and pass the order.
yes,
All right.
yes.
Heard Mr. M.M. Bagaran, counsel for the petitioner, and counsel for the applicant. This is an application for modification of the interim order dated 2606 passed by this court in criminal petition number 136 of 2020. 2025. Issue notice to the respondents as Mr. So-and-so, VP and your name, please.
Though we are not made party in the ILO.
Okay, and as Mr. So-and-so enters appearance and legal notice, no formal notice need be served, so-and-so. This after 2 months, 2 weeks. This after 2 weeks. In the meantime, respondent may file their objection, if any. Okay, next.
That day I saw 3 weeks time, it was granted, but later
So
on.
why this has been listed again?
My lord, at this stage, my lord, may I pray the, my lord, direction may be issued to the, my lord, department to stop, my lord, the construction work, my lord.
There was call. So I sought time for filing affidavit. And when
That was
later on,
01.
01, yes.
Yes.
It was,
Just so.
this order was passed later on, they informed me.
Huh?
I sought a time for filing affidavit. Then again, they come and they request.
That is the problem, my lord. Without filing affidavit, they are undertaking a construction activities.
No, last, age agreed to well and consent by the party. That's why we're very, had to be very careful about even one line order. But we
I am
have
already,
immense faith on the lawyers.
on first, I sought 3 weeks times.
Then
Then actually before the court, it was granted, but this order is very surprising.
No, that is the problem.
Yes. Then later on, when I was on the way, his associate called me that they have sought.
It was taken up again without in your absence.
Yes, that later on she called me, one girls.
In his absence.
My lord, I'm told when the matter was called, I was, my lord, on the way. Then it was passed over for the time
No,
being.
it
my lord.
was not possible.
Then, my lord, then all the list was exhausted. In the meantime, I called my lord, associate, my lord, again mentioned for the, my lord, the listing today, my lord. And by which time, my lord, he may not be, as agreed by, my lord, it was listed today, listed for today, mentioned for today, on which lordship has.
No, that's why I'm saying, we have a faith on the lawyers. So when you have agreed, it said as agreed to by land council by the parties, will not just pass like that.
Even
It's
we,
by me, by the court.
even we didn't agree for the, my lord, listing of the matter after 3 weeks, my lord.
Anyway, what can we do?
So we have to file affidavit.
Affidavit will be
Yes.
required.
No, my lord,
2 weeks
2 weeks, yes.
my lord,
as a last chance. It's of 2025.
my lord, the perpetuate, my lord, the illegalities is still, my lord,
What is this?
my lord, without, my lord, following the due process, NIT was called for. Hurriedly, my lord, they have been awarded and undertaking construction activities without following the procedure, my lord.
Undertaking what sort of construction?
Construction of
The school building,
Of where?
Turu.
only technically one day,
Yeah.
my lord, no NIT, my lord.
Their
Violation
allegation,
of everything.
my allegation is there.
We'll see, there is a provision of disbursement of the profit.
My lord.
If you win, we'll provide. I mean, if the writ petition is allowed,
My lord.
let them construct and we'll apply the principle of disbursement of the profits.
My lord. There is, my lord, settled position, my lord.
Yes, heard Mr.
2 weeks,
Kato, Land Council for the petitioner. Your name is also not there.
Yes.
Land Council for the petitioner. Although this matter has been, it has been fixed on the consent of the Land Council for the parties, but today there is a dispute with regard to the consent. However, considering the matter on the prayer of Mr. G. Tarak, Land Council for the Land Standing Council, Rural Works Department is granted further 2 weeks' time to file affidavit. Mr. It is made clear that on the next date, we'll not say, it is made clear that, on or before the next date fixed, huh? No, Mr. It is made clear that the respondent authorities to file their affidavit on or before the next date.
My lord. Failing which, my lord, on courts, my lord, it will.
Failing which
My lord.
the matter would be taken up for final consideration.
My lord.
Publish.
Deep problem.
Yes,
My lord, this is
Aye.
interlocutory application for condonation, my lord, for
How many days?
198 days, my lord.
So we'll have to issue notice.
Yes.
Mr. Deka,
Yes, my lord.
you Deka,
You take a my lord.
learned counsel for the petitioner. Airline criminal applicant, next by addition and application under section 5 of the Indian Limited Act 1963. Praying for condonation of 198 days, condonation of delay of 198 days, 198 days in filing the connected MSC appeal against the judgment and order dated 17/02/2024, passed in MSC case number 17 of 2022-23 by the learned member, Mesiti Bombila. Issue notice returnable by 4 weeks. Mr. The learned counsel for the petition to take its test for
Yes,
service of notice upon respondents, all the respondents.
Only one sole response.
Sole respondent. By registered for so and so within a period of 2 days.
Okay.
2 days.
2 days. Okay.
Can it be? 3 days,
3 days.
4 days?
Yes, Saturday, Sunday.
Saturday, that's what I'm saying.
Yes, 4 days. 4 days.
No, 2 days. Working 2 days.
Yes, working 2 working days.
Working 3 days. It's okay. Huh?
Offline.
Where is the 17th? Wetland infrastructure.
Lordship, this is a arbitration petition, Lordship. Today, Lordship, it is
Still notice.
notice.
Mr. Judge in learned counsel for the petition. This is an application under section 11, within bracket 6, bracket close of Arbitration Constitutional Act. Praying for appointment of an arbitrator. In respect of what?
In respect of dispute between BRO and
In respect of dispute between the petitioner and the BRO.
yes, sir.
Respondents for the contract, huh?
Lordship, contract work.
Contract work of construction of food track from Surly to Semi, huh?
Correct, Lordship.
On the EPC mode. Issue notice. You are appearing for all respondents. Returnable by 4 weeks. Since Mr. M. Kato London, as a London DSJ enters appearance and accept notice in behalf of all the respondents, no formal notice need be served. Huh? List after 4 weeks.
Obliged.
Wait, Joseph.
Yes.
My lord, this is subject matter is my lord. This dismissal. Sorry. Dismissal from the service, my lord. My lord,
Issue notice if
yes,
this is the dismissal. Huh? Where is the dismissal order?
my lord, at page number 45, my lord. Annexure 8.
Removal or dismissal?
Dismissal.
In your prayer it says removal. Page 40?
45, my lord.
Page 45.
Yes. Operative position for
Dismissal from services accordingly hereby imposed on senior. Okay. 2020.
20, man.
Okay, you file an appeal.
Yes, my lord. This is still pending.
Okay. It's still pending.
Appeal also pending, then my lord, the revision petition also pending.
No, without appeal being disposed of, how their the revision will lie. First, the appeal has to be disposed of.
But it is my lord.
When need to file the appeal? Sir, I think they should need to dispose of the appeal. Where is your appeal? Anyway, I'll issue notice. But then ultimately, your appeal has to be disposed of. This is only for disposal
It
of
is
the
deemed to
appeal.
be rejected, my lord. It deemed to be rejected.
Why did you file? That's why I'm asking.
$49, my lord. Annexure 10.
49.
That
2020. Yes. 5 years nearly.
Yes.
Why you are not disposing at all? Mr. T. Counsel for the petitioner. The challenge made in this petition is today, order dated 26/06/2020, passed by the Superintendent of Police. Superintendent of Police is coming district SEPA, whereby the petition has been dismissed from service. Mr. Issue notice returnable by Monson enters appearance in behalf, enters appearance and accepts notice.
1
in
to
behalf
5,
of
my lord.
all the respondent.
No, my lord, 1 to 5, my lord. 6 and 7.
6 and
is
7
by
are
name-
in private matter.
by name.
Okay, 1 to 5, no formal notice in his behalf, except copy so and so, huh? Please stop. Next para. The petitioner to take steps for service of notice upon those numbers 6 and 7. By registered post so and so. Why 6 and 7, sir?
My lord, there are some,
Aliasing
yes,
malafide. Okay. After 4 weeks, listen. After 4 weeks.
okay, sir.
May I please, your lordship, here I have challenged the suspension order, your lordship.
Okay, issue notice.
Yes, your lordship.
Heard Mr. A.K. Singh, learned counsel for the petitioner. Where is that suspension order?
9/3/24, page
Page
34.
Challenge made in this writ petition is to the order dated. Where it is?
9 March
34.
24. Page number 34, your lordship.
Order dated 9/09/03.
Yes, your lordship.
2024. Issued by the Secretary within Bracket General ADM Administration, huh? Yes, 34. Governing the Arbitration to be issued by the petitioner. Has been deemed to have been suspended with effect from the date of his arrest, huh? Date of his detention, 23/01/2024. Why you have been detained? What is the
In
allegation?
connection with SIC case, your honor. I am working as a private assistant under the director of.
What is your ground? Why you are challenging
Lordship,
this?
thereafter, after the suspension
There is no
order,
review. Even after
on one
90 days.
occasion, there was a review, but on one occasion, they have filed, issued order backdated, your lordship.
Issue notice returnable by 4 weeks, 3 weeks, as MS Arbasar, London State Council, and Mr.
For respondent number 2.
T. Tagore, London Standing Council, Education Department enters appearance and accept notice on behalf of all the respondents. No,
Yes, sir.
no private.
No.
No problem. Notice name is have accept will be furnished to the London Council for the parties. What is this? Item 20?
Not sure.
Oh, that already been.
Lordship, sorry for my distressful resort. Lordship, I would like to mention one item, IN number, Lordship.
Huh?
I would like to mention item number, Lordship.
Item?
IN, Lordship.
For what?
Lordship, this is for continuation of the interim order, Lordship. Actually, this was listed in court number 2 yesterday and day before also. Then because of time, now they have passed order that this may be listed in the appropriate court, Lordship. And this vacation of the recall of the was passed by your Lordship, Lordship. That on that ground, this morning I could not mention because of this order was passed.
Let us see what is there.
Lordship.
But it's not appropriate, huh? You have to take a call on time.
Lordship.
All the time we cannot be lenient, so lenient.
Lordship.
What is this?
Lordship.
Lordship, last order is
This has not been, the interim order is up to when?
Lordship, it was interim order was passed on level February 2025. And next day, Lordship, it was to my unfortunate Lordship. I remember that day, Lordship, that I suffer from the Lordship, periodic paralysis, Lordship. This is my health issue, Lordship. At that time, I could not present before this on Lordship. And now, Lordship, circumstances is that my petitioner is going to celebrate his father's death anniversary on 7, Lordship. And whereas impugn order has passed to warrant issue against the petitioner.
Come to my residence, we'll see.
Lordship. Lordship, this is my stressful resort, in fact, Lordship. And
Oh,
it is
no file, nothing.
Lordship, this is major setback for me also.
There has been recall. Why this has been recalled? Why this has been recalled?
Lordship, for defaulter of the council, Lordship.
Huh?
Non-appearance of the council, Lordship. I could not appeal, Lordship. On medical health ground, Lordship.
We'll see at 2. We'll see. Call the file. We'll see.
Lordship.
Mention memo.